to go.
Great. Good morning, everyone. I'm Cindy Bombard, president of the Central Connecticut Chambers of Commerce, which is based out of Bristol. And we are happy to partner up with the Connecticut Paid Leave so we can all learn a little bit more about what needs to be done with the small businesses, or any business for that matter. But we are the second largest chamber in the state of Connecticut, about 1,600 members strong. And we service the central region, and we also have 2 manufacturing associations that we're very closely tied to. So many of those individuals are here today, and I want to thank you for taking the time out of your busy day to join us. So without further ado, I'm going to turn it over to Erin.
Thank you so much, Cindy. Good morning, everyone. I'm just going to go ahead and share my screen. That I can get to the website. Goodness. Let's try that again. There it is. So as I get to the slideshow here, let me tell you that my name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority, and we're here to talk this morning about the Connecticut Paid Leave Act and the Connecticut Paid Leave Authority and what we do, and how the law is going to change in 2022 in connection with the Connecticut Family and Medical Leave, which is a separate law, so that employers can be prepared for what they need to do this year or what they'll need to prepare for next year. Before joining the Paid Leave Authority, I worked at the Department of Administrative Services for 14 years, running their legal and legislative functions. I understand from Cindy that my former boss, Josh Jabal, who's actually our chairman of the board of the Paid Leave Authority, was here yesterday. So you're getting a lot of DAS people this week. But in addition to handling legal and legislative functions for the state, for DAS at least, I was also very involved in developing the state of Connecticut's family medical leave system for state agencies. I've been involved with FMLA basically my entire professional life. So this morning, we'll talk about the Connecticut Paid Leave Program and the leave laws, and then we'll spend a little bit of time talking about what employers need to know, what your roles will be. And then we'll talk a little bit about private plans, which is an alternative to participating in the Connecticut Paid Leave Trust. And then just in case anyone among you have not yet registered, I want to make sure you know how to register, because that's something that needs to happen. And we'll have plenty of time for questions in the second half of the hour. If you do have questions as I go along, please put them into the Q&A function so that we can keep track of them, and then we'll address all of the questions at the end. So just a little bit about the Connecticut Paid Leave Authority. We're a quasi-public agency. We were created by Public Act 19-25, which is the same public act that created the Connecticut Paid Leave Program and established changes to the Connecticut Fmla. Our purpose is to create a path to allow employees to be able to take leave to care for themselves or to care for a loved one without having to worry about the lost income from being out of work. So we make sure that we can give employees a way to access their paid leave benefits, but we also feel it's as important to make sure that employers, administrators, healthcare providers, and other entities that have a role in the leave process understand what that role is, and we want to make sure we're a resource to them as well. The Paid Leave Authority is responsible for engaging in outreach and education. So doing webinars like this is just such a great opportunity for us to make sure that employers and employees understand the law. We also have to run the paid leave program. So we're working, which, as a brand new agency, we're working to set up those policies and procedures. Our statutory responsibility is to establish the trust fund contribution rate. This is the rate that employees have to remit to fund the paid leave benefit trust. By statute, the contribution rate can be no more than 0.5%, but in the future, as we grow reserves, we have the ability to reduce that rate. We are also responsible for receiving those contributions and transferring them to the trust. And as I mentioned, there is a private plan option that we are responsible for that I'll talk about a little bit more later. Starting next year, we'll be administering the claims for paid leave benefits. That will start in January of 2022. Just a few key dates. This is kind of what guides our life every day, knowing that these deadlines are fast approaching. We started allowing employers to register with the Connecticut Paid Leave Authority in November. You register on our website, which is ctpaidleave.org. Registration is important because it helps us know that employers understand their obligations, and enables us to communicate more directly with employers. It's also where you go to make sure that your contributions are remitted, either if you're doing it yourself or through a third party, and where you go to make sure that you are fully on board with the system, and it's where you tell us who we would be contacting in the future if we have claims that involve your employees. As of January 1st, 2021, the obligation to start deducting the employee contributions began. As I mentioned, that's 0.5%. And so those deductions should have already started. There is a catch-up period. We can talk about that in a little bit. But officially, that obligation started on January 1st. And we've been working to make sure employers know how to do that. The payments are actually received on a quarterly basis, same way that you remit your unemployment taxes and your payroll taxes. We do allow a 1-month grace period, just like Department of Labor and Department of Revenue Services do. So even though the payments are due on the quarter, you're not late unless you go past 1 month. So the first contributions will be received between March 31st and April 30th. And then starting next year, we'll be administering claims for benefits. We hope to be able to start processing those claims before the turn of the year so that we'll be ready to go on January 1st with the paychecks. The first question we're asked is, does this law apply to me? Do I have to pay attention to this? And for most employers, the answer is yes. The law was deliberately drafted to be very broad. So employers who have one or more people working in Connecticut are covered. That means the employees have to make the contributions, the employers have to remit the contributions. This includes nonprofits, this includes private sector employers with unionized workforces. Really, it's almost everybody who has one or more employee working in Connecticut. There are a few entities that by statute are excluded. And these are the entities, these are public primarily entities, which are also excluded from Connecticut Fmla. And that includes the federal government, the state of Connecticut, except as to covered public employees. Municipalities and local or regional boards of education are also excluded unless they have covered public employees. Finally, non-public elementary or secondary schools are excluded. Not specifically listed in the statute are the 2 tribal nations in Connecticut. But because the state of Connecticut does not have authority over sovereign nations, employees of the tribes are also excluded. I have a note here that sole proprietors and self-employed individuals may choose to opt in. So if you own your own business or you're self-employed, you personally are not required to participate, but you have the opportunity to choose to opt in if you want to do so. If you do choose to opt in, you do need to stay on for at least 3 years. I mentioned that the state of Connecticut and towns and municipalities and boards of education are excluded except as to their covered public employees. That term means the non-unionized employees of the state of Connecticut, so managers, appointed officials, and legislators are all covered public employees. So we will be remitting the contributions and we will be able to apply for benefits. Unionized employees of the state may collectively bargain to be included in the program. Similarly, employees of municipalities and boards of education are excluded right now, but if their unionized employees collectively bargain to be included, then everybody, union and non-union, would come into the program. So I've talked a little bit about those contributions, which the obligation began on January 1st, and we're coming very close to the end of Q1, where the contributions will need to be remitted. So the employees pay the contributions. It comes out of their paycheck. It's based on their FICA wages, so you calculate the wages the way you already do to determine your employee's FICA obligation, and you take 0.5% off of that number. The contribution does not lower your employee's FICA obligation. So from that perspective, it's an after-tax contribution. The contributions are limited. Once you hit the Social Security contribution limit, which right now is $142,400, you don't make any contributions after that. So even though the employer does not pay into the paid leave trust, the employer does have the responsibility of processing the payroll to remit the contributions. And we ask for a very minimal wage information, payroll information, so that we can be sure that we're getting the right amount, just at a total level. Those get remitted to the authority, either directly through our website or through batch processing. We'll receive those contributions and validate them, and we deposit the money immediately into the paid leave trust, which is actually administered by the Office of the State Treasurer. And that trust is what's used to fund the paid leave benefits, and also that's where we get our operating expenses to run the authority. So even though the Connecticut Paid Leave Act is a brand new law, it fits into an existing constellation of other leave laws. And so I just want to take a moment to kind of point out the laws that are already on the books that we're kind of adding to. The federal FMLA, or Family and Medical Leave Act, has been the law of the land since the 90s, and that applies to employers with 50 or more employees. Connecticut FMLA has actually been was actually enacted before the federal FMLA. And right now it applies only to employers with 75 or more employees. But starting in January of 2022, it will apply to employers with 1 or more employees. In addition to the 2 FMLAs, which allow employees to take job protected leave, there are a few other laws where an employee may be legally entitled to job protection when they're out of work, including workers' comp for covered on the job injuries. And then with the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act, leave may be a reasonable accommodation. So an employer has to at least consider whether it can provide job protected leave to an employee with a disability. So all of the laws I've just mentioned provide an employee with the ability to take time away from work and have their job protected. So the job held for them. We really don't have very many laws that allow for employees to receive money while they're out of work. Workers' compensation obviously provides for benefits, but that's only for covered on the job injuries. And until we have the Connecticut Paid Leave Act, that's really the first one that says, okay, if you're out of work for a covered condition, we will allow you to receive income replacement so that you can continue to pay your bills, don't lose your house while you're dealing with whatever situation required you to be out of work. Because the Connecticut FMLA is changing significantly, I want to make sure that employers are aware of the change. In addition to the fact that it will now apply to employers with 1 or more employees, there are some other significant changes, which are listed on this slide. The most significant, I believe, is the fact that an employee will be eligible for Connecticut FMLA once they've worked for 3 months, starting in 2022. This is significantly different than the current status, which says you have to work for at least 12 months and you have to work at least 1,000 hours in the 12 months immediately preceding the leave. Starting in 2022, there will no longer be an hours worked requirement. The other change is the amount of time that employees will be able to get. Instead of a 16-week leave in a 24-month period, it'll be 12 weeks in a 12-month period, with an additional 2 weeks that may be available for incapacitation due to pregnancy. There's also 26 weeks of military caregiver leave that's available. That won't change. Finally, there is a change to the rules about when an employer can require an employee to use their earned accruals while they're out of work. Right now, the law says that an employer may allow or can require the employee to use any and all accrued time. But in 2022, the law will change and says that an employer must allow the employee to at least hold on to 2 weeks of accrued PTO. They can't be required to exhaust it while they're out on FMLA leave. As I said, all of these changes take effect in January of 2022, so you do have time to prepare, but it's important to be aware of them. So I keep talking about reasons when people go out on leave and when they have these conditions. Well, there are some restrictions on what is a covered reason for leave. And these are the same reasons that an employee could come to the Paid Leave Authority to ask for income replacement benefits. If you're familiar with federal FMLA or Connecticut FMLA, you'll be familiar with these reasons. And they are to create or expand your family, either through the birth of a child or a placement with you for adoption or foster care, which is usually called bonding leave. You can also take leave to care for a family member with a serious health condition, which is called caregiver leave. Of course, you can take time away from work for your own serious health condition. And the definition of serious health condition includes serving as an organ or bone marrow donor, and it also includes pregnancy, not just childbirth. There is military caregiver leave, which is leave to care for a family member who's been injured in the military. And there's also something called qualifying exigency leave, which is available to an employee if they have a parent, spouse, or son or daughter who's been called to overseas active duty. Finally, it's not actually FMLA, it's called the Connecticut Family Violence Leave Act. And that act says that an employee who is experiencing family violence can take up to 12 days in a calendar year of job protected leave to relocate, go to court, or seek counseling or treatment for reasons associated with the family violence. And an employee who's taking family violence leave can come to the authority for income replacement during those 12 days. Those leave reasons that I just mentioned are the same leave reasons that are available under federal FMLA, with one really significant exception. The definition of family member under the federal FMLA is that the family member is a parent, spouse, or child who is under 18 or is 18 and over and has a disability that prevents them from engaging in 3 or more activities of daily living. So it's a fairly limited standard. In January of 2022, the definition of family member for purposes of Connecticut FMLA and the Connecticut Paid Leave will broaden to a parent or a spouse, a son or daughter of any age, as well as a sibling, grandparent, or grandchild. In addition, an employee could take leave to care for an individual who's related to the employee by law or affinity, whose close association is the equivalent of one of those family relationships. This is a new standard in Connecticut, but it's not a new standard in the law. The federal government has used this related by affinity definition for decades in connection with federal contractor sick leave, bereavement leave, and similar laws. Other states and municipalities also have used this. Basically, it's a recognition that not every family looks like Ozzie and Harriet Nelson, and family dynamics have shifted, and families basically come in all shapes and sizes. So it's a very fact-specific situation. It could be your aunt or uncle who has been like a parent to you, or your great aunt who really you consider to be your grandmother. It could be your unmarried significant other. Connecticut law does not recognize common law marriages, but with this new change, your unmarried significant other with whom you maintain a marriage-like relationship, think of Kurt Russell and Goldie Hawn, that would be a person who's related by affinity. Some basics just to keep in mind, as I said, Connecticut FMLA will be changing to 12 weeks in a 12-month period with an extra available 2 weeks for incapacity during pregnancy, in those 12 days for family violence leave, and the 26 weeks for military caregiver leave. This looks very similar to federal FMLA, which is also 12 weeks in a 12-month period with the opportunity for 26 weeks for military caregiver leave. And with the Connecticut Paid Leave Act, even though we don't provide for job protected leave, we provide for income replacement. The income replacement will be available for up to 12 weeks in a 12-month period. We don't have extra time, or we don't have extra benefits available for the 26 weeks for military caregiver. You only get 12. We do, as I mentioned, provide income replacement for up to 12 days. It's of those 12 weeks, it's not additional. But we do have the 2 extra weeks for incapacity during pregnancy if that becomes medically necessary for the pregnant woman. Even though the length of leave looks similar across all 3 laws, the eligibility requirements are very different. For federal FMLA, the employee needs to be employed for at least 12 months and has to have worked at least 1,250 hours in the 12 months immediately preceding leave. As I mentioned in that earlier slide, the Connecticut FMLA eligibility requirements will change in January of 2022, and it will only require being employed for 3 months to be able to be eligible for job protected leave. For paid leave benefits, we don't actually look at how long the employee's been working at all, because the legislature designed the benefit program to be transferable, to go with the employee if they change jobs. So we just look at how much the employee has earned. If you've earned at least $2,325 in the highest earning quarter, when we look at the first 4 of the 5 quarters immediately preceding the request for benefits, you will be eligible for leave, as long as you are currently employed or you had been employed in Connecticut in the past 12 weeks. When we're looking at that 2325, we can look at all of your earnings from all of your employers in Connecticut to make that determination. So if you've switched jobs or if you work more than one job, we will total up the earnings. All right, so I talked a lot about what the authority does and what the law requires. Let's talk a little bit about what happens with the employer. And this decision matrix is actually something that you probably are doing right now, or should be if you're not, which is anytime your employee asks for time off from work for a potentially FMLA qualifying reason, so their own serious health condition, bonding, caregiver, and the like, the employer must ask itself, is this employee eligible for job protected leave under one or more statutes? And is the employee eligible for any income replacement while on leave? The employer is going to make the decision about the job protection, looking at the statutes. The employer is also going to look at its own policies to decide about income replacement. They don't decide for the authority about who's eligible for paid leave benefits, but they may need to tell their employee, you should call the paid leave authority and see if you're eligible. Every time the employee asks for this time off, you should be thinking about these 2 questions. An employee could be eligible just for federal FMLA. They could be eligible only for state FMLA. If they're eligible for both, so they've worked for more than a year, they've worked the necessary hours, they could be eligible for both federal and state FMLA, in which case the leave entitlements would run concurrently, meaning they'd be drawing down from both federal and state FMLA at the same time. Some employees won't be eligible for either federal or state FMLA, but job protected leave might be a reasonable accommodation under the ADA, the Pregnancy Disability Act, or the Connecticut Fair Employment Practices Act. And some employees won't be eligible for any job protected leave at all. It may be the case that they're a brand new employee or they've already exhausted their leave benefits, in which case, even though they can't come to work, they're not entitled to having their job held for them. It's important for the employer to make this decision based on the law as soon as possible so the employee knows what their options are. With regard to income replacement, as I said, employers have to look at their own policies to determine if the employee is eligible for any income replacement. An employee could receive benefits from both the authority and an employer, either through accruals or other benefits at the same time, as long as the total amount does not exceed 100% of the employee's regular wages. We know that a lot of employers offer short-term and long-term disability policies. You really need to look at the specific language of those policies to see if the employee needs to utilize the benefits from the policies first, or if they need to come to the authority first and either exhaust the benefits from the authority before they can access the short-term disability, or to use the short-term disability to supplement. Most short-term and long-term disability policies say that the insurer is the payer of last resort, which means the employee would use all of the employer-provided benefits and the authority benefits before accessing short-term or long-term disability. The statute does say that an employee who's receiving workers' compensation benefits cannot also receive benefits from the paid leave authority. So if they're out on workers' comp, they have to use that route only. As we'll talk about in a moment, some employers are applying to the paid leave authority to offer a private plan to make sure that their employees receive all the benefits of the Connecticut Paid Leave Act through this private insurance plan, rather than having their employees come to the authority. If you have a private plan, that is the only situation where the employer decides if the employee is eligible for benefits under the Connecticut Paid Leave Act. Just as a reminder, employers may require their employees to use their accrued PTO, but will have to let the employee hold on to at least 2 weeks. As a side note, I do strongly recommend employers consider at least requiring their employees to use their own sick time while they're out on their own serious health condition to avoid stacking, which is avoid having employees layer benefits one after the other. That is an employer's decision, it's not ours, but it's something to consider. So employees come to you and said they need time away from work because they are sick, or they have to take care of their mother who's having a hip replacement, or they're adopting a baby, whatever the story is. You make the decision about if the eligibility for job protection. And you tell the employee if they have to use their accruals. The employee comes to the paid leave authority to apply for paid leave benefits. When they come to us, we will validate that they are eligible based on their earnings and validate that the reason for leave is covered. We calculate the benefit amount, but we have to communicate with the employee and the employer to validate the absences to make sure that we're not issuing benefits while an employee is receiving a salary, and to calculate any offsets based on the employer provided paid time off. And then we'll issue the benefit payments. When I say the authority is doing this, I'm saying that it's going to be done under our auspices, but we are in the process of negotiating for a third-party administrator to handle this function for the paid leave authority. The benefits are set forth in statute, and how much you get depends on how much you earn. If the employee earns less than or equal to the Connecticut minimum wage multiplied by 40, the benefit payment will be 95% of their base weekly earnings. So looking at $12 an hour as a minimum wage, we're really looking at $480 a week. If you earn $480 a week or less, your benefit is 95% of that amount. If you earn more than $480 a week, the benefit amount will be that $480 plus 60% of the difference between the employee's weekly earnings and the Connecticut minimum wage. However, in all circumstances, the benefit payment is capped at 60 times the Connecticut minimum wage, which right now would make it cap at $720 a week. Just a couple of examples to kind of bring that to light. It's sometimes easier to understand it with the math. It's kind of showing. We like to show our work here. So Mike is earning $375 a week. His benefit payment would be 95% of that, which is $356.25. Deborah, on the other hand, earns $700 a week. So we look at Connecticut minimum wage times 40 plus 60% of the difference between the 700 and 480. And you add those together, and so we see that Deborah would receive $612 a week in benefits from the paid leave authority. All right, so we recognize that this is complicated for employers. And so we wanted to just kind of use an example to put it all together, how the leave works with the accruals. So I have Wiley Coyote here, who's been working for Acme Industries for over 10 years. Acme has 100 employees. Wiley's been there for full time. He's already accrued 4 weeks of sick time and a couple weeks of vacation. When he injures his hands and needs to be out for 8 weeks. Looking at that decision matrix, we know that the employer has to say, is Wiley eligible for any job protected leave? And what are Wiley's options for income replacement benefits? So let's look at how this plays out. We know Wiley's worked for Acme for over 10 years, so he's clearly met the eligibility for Connecticut Fmla. Acme has 100 employees, so it's subject to federal FMLA, And we're going to assume that Wiley was worked the 1,250 hours needed since he's a full-time employee. And we're going to assume for purposes of this that he's earned the $23.25 needed to be eligible for Connecticut paid leave benefits. So if Wiley hurt his hands over the weekend playing with fireworks, which he should not have been doing, he would be out of work starting on February 1st. The Connecticut FMLA and federal FMLA will run concurrently, meaning he's drawing down his entitlements from both laws at the same time. And so those leaves will carry him through the end of March. But his employer-provided PTO won't cover the full amount of time. The employer requires Wiley to use his sick leave accruals. So the first 4 weeks are covered by sick leave accruals. The employer cannot require Wiley to exhaust the last 2 weeks of the vacation time. So Wiley would come to the paid leave authority in March and receive 4 weeks of income replacement benefits. Now, Wiley is accident prone, as we know. So if he ever injures himself later in the year, he'd only have 4 weeks left of Connecticut FMLA and 4 weeks of federal FMLA available to him. But he would have up to 8 weeks of income replacement in the event he's injured in the future. Okay, private plans, just briefly. Connecticut General Statute 31-49O allows employers to meet their obligations under the Paid Leave Act by offering their employees a private plan. This could either be a fully insured plan or it could be a self-insured plan supported by a surety bond. The plan has to be approved by the Paid Leave Authority. And if we approve it, then the employer is responsible for handling the employee's claims for paid leave benefits. An employer with an approved plan is not required to remit the employee's contributions to the authority. That obligation is waived. And the employer has the right under the statute to withhold a portion of the employee's wages, but they can only do so for the sole purpose of administering the plan. They can't take those withholdings and just pool it together with other benefits or use it for operating expenses. It can only be used to run the private plan. And that withholding cannot exceed whatever the authority requires employees to contribute to the paid leave authority, which right now is 1/2 of 1%. If our contribution rate goes down, the private plan contribution rate would have to go down as well. If you're interested in applying for a private plan, all of the information that you're looking for can be found on our website, which is www.ctpaidleave.org, and look for the I want to apply for a private plan page. The plan must offer the same or better benefits as the program we offer, which means it has to cover all the same reasons. It has to have the same amount of money provided for the same length of time. Short-term disability policies just don't do that. So if you have a short-term disability policy that you're already providing, that's not going to be enough. As I said, it can't cost your employees more than 0.5%, and it must cover all of your employees. If you are a multi-state or multinational, the plan only has to cover your employees working in Connecticut. We don't have jurisdiction beyond our borders. Because the paid leave program is employee funded and it's an employee benefit, the statute requires that in order to provide a private plan, the majority of the employees working for that employer must approve it. So you have to hold a vote of your employees working in Connecticut, and a majority of those employees have to approve your private plan before you can apply to us for your benefits. If you are interested in a private plan, in lieu of making your Q1 contributions, you need to act fast because you need to receive approval before March 31st. If you decide that you want to start in the public plan and change your mind and do a private plan later, that's perfectly acceptable. There are a number of insurance companies that are offering private plan, are approved to provide Connecticut FMLA plans, and a list of them are here. Or as I said, you could offer a self-insured plan. If you choose to offer a self-insured plan, go back to our website, go to that policy that's indicated by the arrow, and you'll find a template for a self-insurance plan, as well as the information you need to obtain a surety bond. The surety bond is to run to the benefit of the authority. It's not there to provide you with money to pay the benefits. It's there to protect your employees and the authority in the event that the self-insured plan doesn't have enough money, and the employees end up being placed into the paid leave program. So it's there to give us the contributions that we would have lost. Okay, real quick, if you haven't registered, you need to do so. That enables you to make sure that you can make your contributions, which are due at the end of the month. And if you're not registered, you won't be able to do it. And not withholding your contributions and not remitting the contributions puts your business at risk, because you could be held responsible for making up those missed contributions. We do have a catch-up period. If you have had trouble getting your contributions processed, if you're having trouble with your payroll system getting it calculated, you can take additional contributions out of your employee pay up to 1% retroactively. I'm sorry, you can take those extra contributions out up to 1% to catch up your payments. But you have to be totally caught up by the end of the second quarter. If you're not totally caught up using those retroactive payments that are approved by Department of Labor, then the employer is going to be responsible for the shortfall. To register, first you need to create an account with ct.gov. This is the business one-stop. If you are already registered with ct.gov, you use those credentials, and then you come to the Paid Leave Authority and click on the button that says register. If you haven't obtained credentials through ct.gov, then you need to go to business.ct.gov, click on the button to register your business. You'll get credentials from them, and then you'll use those credentials to come to us. Our website is ctpaidleave.org, and it has all sorts of information, specifically for employers, for employees, for third-party payroll providers. It's got website, it's got videos, it's got FAQs, it's got videos on how to register, videos on how to make your contributions, all sorts of information, including the employer toolkit. We want employees to understand what's going on, particularly when they start seeing that money is coming out of their paycheck. So we created information for you to share with your employees, including a poster, paycheck mailer, and fact sheets that you can share with your employees. So before I turn this over to questions, just a reminder, register, 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 register. If you use a third-party provider to do your payroll, we've most likely already dealt with them. We've been dealing with the payroll community for 9 months now. But belt and suspenders, make sure that your payroll provider is ready to go. And then educate your employees. Make sure they understand about the contributions and about the benefits that will be available next year. And then bookmark us, ctpaidleave.org. We update our website frequently. We have new FAQs and videos posted. We have new information posted. New functionality is getting launched kind of on a monthly basis. So keep checking in. If you have questions that we don't get to, or if you think of them later, you can go to ctpaidleave.org and click on the Contact Us tab and submit your question, and we will respond to it. All right, I'm going to stop sharing my screen. I did see a couple questions come in. Amber, do you want to let me know what people have been asking?
Sure, we have a few in the chat, so I'll get started with those.
Amber, you went on mute.
Sorry about that. Thank you. I just wanted to let everyone know before we start the Q&A that you will receive a copy of this presentation deck, as well as a link to this recorded webinar. So we do have a few questions in the chat, so I'm going to go ahead and start there. Okay, Erin? This one is, I'm a Rhode Island company with an office in Connecticut. One employee lives in Connecticut, one employee lives in Rhode Island. The only person eligible is the CT employee, correct? Even though the office is in Connecticut?
Actually, if the office is in Connecticut and both employees work in Connecticut, then both employees are eligible, or assuming they make the 23-25, but both employees are covered under the Connecticut Paid Leave Program. Our program is based on where people work, not on where they live. So we really want to focus on that part of it.
Okay, great. Thank you. And let's see. How is the amount of FMLA benefit determined? Is it a percentage of the gross earnings or is there a max amount?
So as I mentioned, the benefit is determined by that two-part process. It is 95% up to 40 times the Connecticut minimum wage, or if you earn more than that, it's the 40 times the Connecticut minimum wage plus 60% of the difference, capped at 60 times the Connecticut minimum wage. The definition of wages is basically looking at the average of your remuneration for the past 2 quarters. Sorry, it's the highest, it's not the past 2 quarters. We look at the wages that employees received in the highest earning of the 2 quarters, looking at the first 4 of the 5 quarters before the leave. That first 4 of the 5 basically is a recognition that the Department of Labor doesn't get wage information until the end of a quarter. So we don't have immediate access. That's why it's the first 4 of the 5.
Okay, thank you. Let's see. Current state law says that an employee can have disability insurance up to 72% of gross earnings. Will that change?
So I'm assuming you're referencing to the tax code. I'm not sure which law you're talking about in terms of that 72%. So there's no change to the benefits that an employer could provide to an employee through short-term disability. There's certainly no change to the tax consequences of that. This is just another benefit. What I will say, though, is you can't, although you can combine benefits, that you can't combine them above where an employee would get 100% of what they would be getting if they were working. So it's just another benefit that goes into the mix if the employer does provide short-term disability to their employees.
Okay, thank you, Erin. And another here, we are a church, and I'm not sure whether our church is registered. Is that information available online and where?
So to find out if you're registered, go to ctpayleave.org and click on the registration button. If you're already registered, we'll tell you. Churches are covered, so we do want to make sure that churches and other nonprofits and not-for-profits understand that they're required to register as well. So if you're not sure, then you can't just ask your bookkeeper or payroll person. You can go on and if you're registered, we'll let you know.
Great, thank you, Erin. All right, that concludes our questions. If anybody has any further questions, please utilize the Q&A feature at the bottom of your screen. It just helps us keep track of who we've answered and who we have not. So I'm going to go over to the Q&A now. And this one is asking, can we touch base on how the employer will submit payment to the state for this program? So I'm guessing they're asking about contribution remittance.
Yeah, so the payment portal, we have been undergoing a lot of testing, quality testing, user acceptance testing, all sorts of testing. So that is going to be going live very shortly. There are videos that will be posted about how to submit payment. There's basically 2 ways. One is to go to ctpayleave.org and just remit it through the website. Alternatively, there is a batch process. There's information on the website. The batch processing is usually used for very large employers or those third-party payroll providers, but there's information on the website, and we will be releasing the videos as well.
Thank you, Erin. All right, if we have under 75 employees now, do we have to make contributions now and take those funds from employees before January 1st, 2022?
Yes, you do have to make contributions now because the contribution obligation began for all employers with 1 or more employee in Connecticut, with the exception of the ones I listed, on January 1st, 2021. So the contribution started in January. You do have that catch-up period if you need it. And then in January 2022, the leave law will change.
Okay, thank you. And how does the state verify those family relationships that are outside of immediate family?
Right, so that is a question that we're working on with the Department of Labor because it's the same standard. That definition of family applies to both the Connecticut Paid Leave Act and the new Connecticut FMLA. So we want to make sure that we're in the same place with the Department of Labor so that employers have consistent guidance. I can tell you that right now, under existing Connecticut FMLA and federal FMLA, there's something called in loco parentis, where you can say that even though you're not the biological or adoptive parent of someone, you stood in the place of a parent. You were in loco parentis. And there are regulations about the documentation you can obtain to demonstrate your in loco parentis. So I believe that we'll be following that same documentation requirement.
Great, thank you. I know we've had a lot of questions about that. How will the Connecticut Paid Leave Authority communicate to employers? Does it go to holders of the tax account or can it go to HR?
Well, you tell us. When you register, you let us know who you want us to communicate with directly. Certainly for the contributions, it's usually someone who's handling the money. But then you can also identify additional people who would be the ones to communicate with in connection with claims in the future, which would more likely be HR. You can actually provide us with several contact people.
Great, thank you so much, Erin. And there was a question that had come in. I slipped past it real quick. It was regarding employees that live in New York City but commute to a Connecticut office. And so, yes, they would be covered under the plan because they are working in Connecticut.
Yeah, I do want to make one, I want to describe sort of one little nuance there. If you're working full-time in Connecticut, it's very easy. You're part of us. If you're working full-time in New York, you're part of the New York Paid Leave Program. If you're working full-time in Massachusetts, you're part of the Massachusetts Paid Leave Program. Rhode Island has a paid leave program, so does New Jersey. So sort of in our general area, we look at the full-time employees are easy. We know that some people work in multiple states, in which case we really are looking at where you primarily work. Usually we use the unemployment insurance status. So what state are you paying unemployment insurance into? But basically it comes down to sort of substantial presence. Where are you primarily working? So if you primarily work in New York City, but you sometimes come up to Connecticut, you're going to be under the New York plan.
All right, Erin, thank you so much. Cindy, I'm going to turn it over to you. That concludes our questions.
Great. I want to thank Erin and Amber very much for coordinating this with the Central Connecticut Chambers of Commerce. It's an important issue that many of our members had called our office to find out how to do this. So on behalf of the Central Connecticut Chambers of Commerce, I want to thank both of you and the Connecticut Paid Leave Authority on providing this webinar for us. And also, I've been asked, some texts have come through. Will this PowerPoint get out to those that have attended today? And I know they can go to the website and probably find the same thing there, but having that presentation that you did, Erin, would be very helpful.
We will be sharing the slides and the video will be posted, so anyone who registered with you can get access to it. And then we will also be doing more webinars where we've been focusing a lot on the mechanics of registration and contributions. And once those kind of get underway and people are comfortable with that, we are transitioning to more detailed about actually managing leaves. We know, particularly with smaller employers who've not been subject to federal FMLA, it's a whole new world. So we're developing more content on those areas as well.
Great. And anything that we can do to help you get the word out, let us know. We are working with all our municipalities in our region, and I believe many of them are attending here today. So again, thank you.
Great. Thank you so much for inviting us.
Great.
Thank you so much for having us, everyone. Have a great day.
Bye-bye.
Bye.